Hi, my name is Owen Pinkerton. I'm joined today by Cindy BA. We are both partners at Evershed Sutherland in the investment management and BDC group. Today we're going to talk about registered closed-end funds, specifically interval funds and tender offer closed-end funds, both of which are registered funds but are non-listed. And we think it's an important thing to talk about in light of, despite the fact that this is part of the BDC Roundtable series, and these are not BDC structures, because more and more we're seeing that these types of structures are effective complements to BDCs, and in some cases are alternative options for investment strategies that don't work perfectly in the BDC structure. To give you a sense of the landscape, there are over 80 interval funds that are active in the market today. Smaller number of tender offer closed-end funds, but that number is increasing. Both of them are increasing. You see new filings by interval funds and registered tender offer funds all the time. There are about 10 interval funds that have assets of over $1 billion, and the largest is close to 15 billion. So it's a sizable market. It's becoming more and more sizable all the time. Most of the interval funds and tender offer funds that are out there right now were formed and launched prior to 2017. So even though it's not a new structure, it's become a more widely used structure in recent years. So today we're going to talk about the overview of what interval funds are, what tender offer funds are, compare them to non-traded BDCs, for example, and talk about the regulatory environment, how that has changed in the last 12 to 18 months, in some ways harmonizing some of the regulations that have previously been very, very different for the different structures. And then we'll finish off by talking about some of the advantages of the structures and some of the other things to be wary of or to be aware of, if you decide you want to go down the path of forming one of these funds. So Cindy's going to lead us off with talking about how these funds are structured.
Yeah, thanks, Owen. We just wanted to give a little bit of background about these fund structures for those who may not be familiar with them. Specifically, wanted to start discussing the differences between tender offer funds and interval funds. As Owen mentioned, both of these are non-traded registered closed-end fund structures. And both do offer some limited liquidity to their shareholders through periodic repurchase offers. And that is really where the main difference lies. There are some other differences, and some of those have actually been eliminated through recent developments that we'll discuss in a bit. But the difference in their repurchases and sort of related aspects of that is really the main difference between the two structures. Starting first with interval funds. An interval fund is, it's a registered closed-end fund that has elected, pursuant to a fundamental policy, to make periodic repurchases of its shares. The term fundamental policy under the 1940 Act refers to a policy that can't be changed except through shareholder approval. So once a fund is an interval fund, it can't cease being an interval fund without having shareholders vote on that. It does require a sort of rigid structure for repurchases, and there is a lack of ability for the board to determine that there won't be a repurchase. The rule pursuant to which this election comes under and all of these requirements is Rule 23C3 under the Investment Company Act of 1940. The rule provides that the interval, which is of course the term where the term interval fund comes from, but that the interval of such repurchases needs to be either annually, semi-annually, or quarterly. So technically you can have an interval fund that only repurchases its shares once per year. In reality, though, that's not really something that the market will support, at least from what we've seen. I believe that every interval fund that is currently in operation repurchases its shares at least quarterly, and there may be one or two exceptions, but it really is the market to have this done quarterly. On the other side of the time period, there are a few interval funds that have obtained exemptive relief to do the repurchases monthly, so to do it more frequently. So there's only a few of those, but so the general idea is that the periodic liquidity should be at least quarterly to allow your shareholders to have some access to having their shares repurchased. The amount at which this repurchase offer needs to be is between 5 and 25% of the outstanding shares. So that's something, we'll contrast that with tender offer funds, which have an ability to have a smaller amount than that. There's two related requirements that impose restrictions on interval funds. One, which is that while the fund is making is continuously offering its shares, it needs to do a daily NAV. So it needs to calculate its NAV or net asset value in the same way that you would see a mutual fund do on a daily basis. The other requirement is with respect to the repurchases. So during the entire repurchase period, an interval fund needs to hold 100% of the amount that's offered for repurchase in either liquid securities or cash. So as you can imagine, this does put some restrictions on the type of investments that the fund can make, or for at least a portion of its assets. Turning then to tender offer funds, again, generally, these are funds that are continuously offering their shares. But instead of having a fundamental policy to repurchase, the funds generally make disclosure in their prospectus that they intend to make. Again, it's usually quarterly tender offers, but there's more flexibility here because it's not pursuant to a policy. But most tender offer funds do quarterly repurchases. The amount can range, and in some cases, the amounts can be much smaller than the 5%. There is more flexibility in terms of how these funds can satisfy the repurchase offers. They do not have the same requirement to hold 100% of the amount of the repurchase offer in liquid securities. They have, again, more flexibility. They can draw down from a line of credit, for example, at the time that they're satisfying their tender offer. The tender offer materials in and of themselves are actually much longer and require additional disclosure than you would see in the repurchase offer that an interval fund needs to make. And those do need to be mailed to shareholders. So it's a sort of a fairly large disclosure packet that does need to go out. And so those are that's the main difference between these two types of fund structures in terms of the repurchases. When you look at the registered closed-end funds compared to a non-traded BDC, there are more significant differences that we'll go into more detail, but just to highlight, non-traded BDCs, because they are not registered investment companies, are not exempt securities under for state securities law purposes, and so they do have state blue sky requirements where the state securities offices do substantively review the prospectuses for a non-traded BDC, which, as you can imagine, is a significant negative of that product structure. And interval funds and other tender offer registered closed-end funds don't have that drawback because they are registered investment companies. The state securities requirements also impacts how a non-traded BDC can be sold and how that is different from these non-traded closed-end funds. And Owen will touch on that more in a bit. The other difference, which is that a non-traded BDC also needs to file its registration statement with FINRA. And this is a change. Interval funds have not had to file with FINRA, but tender offer funds have, except for a recent change that we'll discuss in a bit, that whereby most tender offer funds should actually be able to be exempt from the FINRA filing requirements too. And so again, that requirement for a non-traded BDC is a pretty significant drawback for that type of structure in terms of ease of launch and ease to come to market. So Owen, I don't know if you have anything else to add on that, or you can turn it back to you to talk about some of the different distribution considerations.
Thanks. I think that's a good segue, because I think that's that's some of the considerations that I think have led to the increase with interval funds and tender offer funds. To take a step back, I think non-traded BDCs, we'll start there. really started to, well, the first one launched in the beginning of 2009. They had a tremendous amount of success raising capital for the first couple of years. Peaked in 2014. I think they sold about $5.5 billion of securities that year, and then started tailing off from there for a number of reasons, and some of which are completely beyond the scope of what we're talking about here. But a couple of things that are relevant to what we're talking about that really influenced a move to a different registered closed-end structure, like an interval fund or a tender offer fund. There are a couple of issues with the non-traded BDC model, and some of these have been fixed or have been reworked in recent years. But going back to 2014, a lot of the interval funds launched in 2016 or after. So when the non-traded BDCs were struggling, there were a couple of issues that people took note of. One of which was complexity, and Cindy's touched on this a little bit. The non-traded BDCs, because they're not covered securities, and the BDCs are not registered under the 40 Act. They have to file with all the states, be substantively reviewed, and just from a timing perspective, even the states that weren't difficult to deal with, it could take 6 months or more to get clearance from those states, and until you get the clearance, you can't sell in those states. So it became very, very burdensome. You also have to update the blue sky every year, and so the registration for some states, it could be open to comments a second time around, or every year that you're selling. In addition, as Cindy noted, the FINRA process is much more robust. It's much more, they're focused on a lot of different things, non-cash comp, employees that work with the broker dealer and with the sponsor or the advisor. Almost all the BDCs that were traded, almost all the non-traded BDCs had affiliated broker dealers, and so they were sold through this this distribution program where they were selling through independent broker dealers, through selling agreements and various things like that. And keeping track of that from a FINRA perspective is very, very difficult and time consuming. And the other thing that the states impose and FINRA also imposes are suitability requirements. And so anybody who, if you're investing in a non-traded BDC and you live in state A, and I won't name names here, but if you live in state A, you might be subject to a 10% net worth requirement where no more than 10% of your net worth can be invested in non-traded BDCs and non-traded REITs and all these other different things. Whereas if you live in state B, you're not subject to any of that. And that's completely up to the state. But it also generates from the fact that the FINRA rules require that DPPs, as they're called when BDCs fall under that category, are subject to suitability requirements. In other words, these products are not suitable for everybody, and so there's a certain net worth requirement for everybody, and then on top of that, a certain percentage of your net worth can only be invested in these products in certain states. And so all this gets reflected in long subscription agreements that investors have to fill out and check the box in different areas. That is not, people don't like long subscription agreements to the extent they can help it. And RIAs really don't like long subscription agreements for their clients. And so some of the advantages that the interval fund and most tender offer funds have as well is that you can get a ticker symbol, and you can, if you have an account through Schwab or TD Ameritrade or something else, and that account is held by is through a registered investment advisor that you work with, you can click on the ticker symbol and you can buy shares or you can sell shares. And I'm sorry, not sell, just buy shares. And that's just a big difference between a non-traded BDC. It's something that in addition to that, I think because of the mandated repurchase requirements that an interval fund has, it's a lot easier for an RIA as a fiduciary to endorse an interval fund for its clients and allocate that across their clients. That's something it's a lot more difficult to do with a non-traded BDC because you don't have the same sort of certainty about liquidity. So most of the interval funds and tender offer funds are sold through platforms like Schwab and TD Ameritrade. So it's and they're sold through RAAs. And so if your RAA, if you have an account through your RAA through one of these platforms, then that's where you would buy your shares and your shares would be allocated. It's a different distribution model than what non-traded BDCs have. Like I said, they mostly sold through the independent broker-dealer channel. They had a lot of trouble being able to get traction through the RAAs. And so, again, this is where interval funds and tender offer funds were seen as a more suitable investment for a lot of RAAs. I think that's all I have on that. We're gonna turn next to recent regulatory developments, and in the beginning it highlighted the fact that there's been some efforts to harmonize these because these are very different structures and they've been historically regulated very, very differently, and there have been some efforts by the regulators to try to treat them a little bit more similarly. But Cindy, you want to pick it up from there?
Sure, I'm going to highlight two recent developments that really treat tender offer funds much more like interval funds that are certainly a welcome development in that area. The first is FINRA. As I sort of introduced earlier in the presentation, most tender offer funds should now be able to come with an exemption under Rule 5110 and be treated instead like interval funds, which are in turn regulated by FINRA in really the same way that a mutual fund is regulated. This change to Rule 5110 was actually announced on March 20th of 2020, and it became effective September 16th of 2020. So fairly new. It's not something that we have seen a lot of press on. I guess maybe people were a little otherwise occupied in March of 2020 with some other news. But the change to the rule exempts from Rule 5110, a closed-end investment company that that makes tender offers as long as it complies with certain conditions. Those conditions are that it has to be making a continuous offering, that it has to price its securities at least quarterly, and that it has to comply with Rule 2341, which is again the rule that regulates interval funds and also the rule that regulates mutual funds. It regulates the 2341, unlike 5110, really just regulates mostly the actual sales charges that are imposed either upfront, ongoing, and also on at the back end for if any redemption or repurchase. Unlike 5110, which really looks at more all elements of compensation is sort of the term that's used there. So it's a different way of regulating and reviewing the underwriting compensation. The other requirements that a tender offer fund needs to comply with in order to be exempt from 5110 is that it needs to make at least 2 repurchases pursuant to the tender offer rules, and also that it does not list its securities on a national securities exchange. So given those factors, most tender offer funds should be able to be exempt under 5110, again, as long as they're willing to comply with 2341. So that's the FINRA rule I wanted to highlight. The other rule change is on the SEC side, and it's a distinction that that's now eliminated, but that had existed for a while, which is how these different types of fund structures are able to update their registration statement. Interval funds had been able to use Rule 486, which provides for, pursuant to 2 separate paragraphs, either immediate effectiveness if you're only making a minor changes or changes that are pursuant to a small list of changes that you're allowed to make, and then also effectiveness within 60 days, which does provide for SEC review, but would be if you were making more substantive changes to your prospectus. until last August, or tender offer funds were not permitted to use Rule 486 and had to instead file a POS 8C to update their offering document, which does not have any sort of guaranteed timing of effectiveness. I mean, the SEC would usually try to review it, pursuant to internal guidelines, but there was no sort of effectiveness date built into the POS 8C, and the funds had to actually apply, a request to the SEC to declare the registration statement effective. And so this is definitely a very positive development, particularly for a tender offer fund that really isn't making any changes to its prospectus and is only, incorporating its updated financial information. That would fall under the immediate effectiveness paragraph, and it would allow that fund to, file an update to the registration statement that goes immediately effective without, not being subject to SEC review, which, was something prior to this rule change that was not possible. So I'm going to turn it back to Owen to cover some additional changes in the past year to year and a half for these types of fund structures.
Thanks. And to tack on to the 486, that also is applicable for non-traded BDCs as well now, and which was, in my mind, a little bit surprising. I was surprised that they did that because that wasn't part of the proposed release, but it ended up being part of the final rule adoption. And having lived through that, the difficulties associated with having year-end financial statements filed in a 10K, by March 31st, and trying to then turn that into a post-effective amendment and get that effective before April 30th was hugely challenging. And the staff wasn't always that helpful in getting comments as quickly as possible. So it's a big development for all three, for the tender offer funds and for non-traded BDCs. The same rule, final rules covered a bunch of other communications reforms that were always in place for operating companies and were understood to be in place in some cases for registered funds, but were never, but not for non-listed funds. And so there, the ability to rely on the Rule 134 safe harbor, which is basically a tombstone act, is something that is well rooted for all operating companies. There's certain information that you can talk about, that you can put in a press release or in a notice that is not considered to be an offer, and it's always been considered not to be an offer. But Rule 134 always had something at the end saying this is not applicable to BDCs and investment companies because they have their own advertising rules, which of course did not have anything like that. So it was never very helpful, but it was always something that was it was something that we used and we thought was a good analogy. But now it's in practice, it's actually it is available for BDCs and registered closed-end funds. Pre-writing prospectuses are also able to be used by tender offer funds, interval funds, and non-traded BDCs as well. And that was not the case before. There are one thing that was not included. There was one thing that was included in the proposed rules, but was not adopted, which would have been another area where they could have harmonized the regulations. But there's too much of an uproar from, I think, the closed-end fund community was to have closed-end funds file 8Ks. BDCs, obviously, as 34 Act issuers, are required to file 8Ks for any sort of material events that happen. The SEC had proposed that the closed-end funds also be required to file 8Ks, but that was not a very popular position, and it got a lot of pushback, and ultimately they did back down on that. So that was, and for closed-end funds, I think, one of their arguments was not only is this burdensome, and this isn't something that people are looking for, but it also doesn't work very well for the business. the business is a little bit different, and the 8K requirements don't really work very well for what they do. So that's one area where they were trying to harmonize, and they didn't get there. One other area is that incorporation by reference. Tender offer funds are now able to backward incorporate by reference their annual reports. That's something that historically has been a challenge for non-traded BDCs, and it's but that continues to be an issue. So as I mentioned before, not everything was harmonized. There's one notable difference, one notable area that relief that was given to interval funds that was not given to others, which Cindy will talk about now.
Sure. Yeah, so this is one, again, big difference. It's a great win for interval funds to be able to do this, but unfortunately tender offer funds cannot. And that has to do with how securities are registered. Interval funds were basically given the relief and the ability to register their shares in the same way that mutual funds and 40 Act, and ETFs register their shares, which is basically paying, after the fact, rather than having to decide how much you want to register up front and paying that fee when you file the registration statement and before it goes effective. Interval funds are permitted to pay after the fact, after they sell their shares. So again, that's a very helpful development for interval funds. To conclude this presentation today, Owen and I just wanted to cover a few things in terms of anyone who is thinking about this type of a structure, things that that are benefits, and generally just things that you need to be aware of and consider. So I'll turn it first to Owen.
Thanks, Cindy. So there are certain aspects of the interval fund and tender offer closed-end fund structure that work really well, that are worth highlighting. And some of these we've talked about a little bit, but one thing we haven't really talked about so far is asset classes. And so for the first area where you saw a lot of interval funds that came out doing, their focus was on real estate related securities. And that doesn't work very well under a BDC structure. And it also doesn't work very well under a mutual fund or an ETF structure, although people will try here and there. But generally, they're not very liquid assets. But at the same time, they wouldn't comply with the 70% requirement that BDCs have. So you see a fair number of interval funds and tender offer funds that have a real estate focus. You've also seen a lot recently that have more of a some of them have a private equity focus and real assets, infrastructure, other things like that. And again, these asset classes don't work well under a lot of the other structures. Some of the interval funds and the tender offer funds are privately offered, and especially the private equity ones, because they want to be able to get a carried interest. And if they get a carried interest, you can only sell to qualified clients, which is a much higher level than even accredited investor. So there's been a big increase in that area because I think that this wrapper works well for that. It offers liquidity, but it doesn't offer too much liquidity, and so that kind of an asset class would works well here, but maybe not in some other areas. Certainly not mutual funds, for example. We talked about distribution. I think distribution, mostly from the standpoint of the lack of subscription agreements and being able to get a ticker symbol, has been very, very helpful for a lot of issuers. The upfront expenses associated with launching an interval fund or a tender offer fund, as compared to a non-traded BDC, are significantly less. For a non-traded BDC, you have to pay FINRA filing fees, which can be very, very high. You also have to you have to pay the blue sky fees, not only the legal fees associated with getting through all those states, but also the registration fees that the various states have as well. So for a new sponsor, there's a lot less of an investment that needs to be made in startup expenses for an interval fund or a tender offer fund. And one other thing that we've already touched on is RIAs are very comfortable with this structure because of the mandated liquidity, especially the interval funds. It's something that they can, as a fiduciary, are able to, it's easier for them to decide that this is an appropriate allocation for their clients. So those are some of the benefits. Cindy's going to talk about some of the things to be aware of, and if you go down this road.
Sure, that's a good segue in terms of RIAs being comfortable with this type of fund structure. I guess the flip side of that is RIAs have a lot of funds competing for their attention, and given that these funds are generally sold through RIA platforms, you really need to show sufficient interest in the fund, be part of a bigger platform in order to get their attention and to be on to be listed on these RIA platforms. So I think the barrier to entry is really in any new entrant in the asset management space is huge, but that's one thing to consider. There are, in terms of comparing this structure to to the non-traded BDCs, as everyone's probably aware of, have more flexibility on leverage than closed-end funds do. So, if the structure for the investment goal of the fund is to utilize, to be highly levered, a BDC is going to allow more flexibility in that area than a closed-end fund. BDCs also have less restrictions on, or they have easier to comply with restrictions on affiliated transactions. The version of the affiliated transaction rules for BDCs is a little bit more flexible than what a registered closed-end fund is required to comply with. And those are, affiliated transactions and how those impact any of these investment companies sort of outside the scope of this presentation, because it's a very complicated area, but it is, again, something to consider when, trying to operate in this platform. And then the other issue that we briefly touched on too is that a BDC is permitted to have an incentive fee on capital gains, and whereas a registered closed-end fund is a public offer registered closed-end fund is not. So those are, again, just a few things to consider and to think about. Owen, anything else you wanted to add that I might have missed?
No, I don't think so. I guess we can close it from there. We appreciate you taking the time to watch this, and this is a space that is continuing to grow, and there doesn't seem to be any sign that that's going to slow down in the near future. It's a good complement to BDC structure. So you see a lot of asset managers that have a BDC and also have an interval fund, or at least are an advisor to an interval fund, or a tender offer closed-end fund. And there's some bigger names that have entered the space in the last few years than were there previously. So not only are there more sponsors that are getting into the space, but they're bigger names, which is always a good sign that it's a growing area. So if there are any questions, you can call either one of us, and we'd be happy to answer those questions. Otherwise, we appreciate taking the time to watch this, and thank you very much.
Thank you.